Part 3, evidence. Hearsay, all the exclusions, and all the exceptions. First, the definition of hearsay. An out-of-court statement offered to prove its truth. Hearsay is inadmissible unless an exclusion or an exception applies. Repeat after me. 1, an out-of-court statement. 2, offered to prove its truth. 3, hearsay is, that's right, inadmissible unless an exclusion or exception applies. All right, try to get all 3 parts. Hearsay is, that's right, hearsay is an out-of-court statement offered to prove its truth. Hearsay is inadmissible unless an exclusion or exception applies. Okay, what is a statement? Does it always have to be a verbal statement? No, it can be what intended as an assertion? That's right, conduct intended as an assertion. Remember, for each hearsay question, we will analyze each statement. Each has to qualify for an exception. Otherwise, the entire statement is inadmissible. So we're always looking for hearsay within hearsay. Does it fit into an exclusion? Does it fit into an exception? But our number one sentence before we start any question, hearsay is an out-of-court statement offered to prove its truth. Hearsay is inadmissible unless an exclusion or exception applies. Okay, let's talk about the 5 categories of things that are never hearsay. 1, 2, 3, 4, 5, never hearsay. Number 1, legally operative language. So this would be language of contract, offer and acceptance, language of a gift, or, for example, the actual words of defamation, because defamation is, as you know, a statement that is published to a third party concerning the plaintiff that harms the plaintiff's reputation. Legally operative language. You speak the defamatory words to a third party, you have defamed. That was legally operative. You are now liable for defamation. I accept your contract. That is legally operative language. Okay, so that's category 1, legally operative language. Category 2, statements offered for notice or knowledge. Notice or knowledge. What does that look like? I noticed that your car door is open. How about effect on the listener? That's number 3. Statements offered for their effect on the listener. So this will generally go to motive or intent. There's a statement in the question, and its effect on the listener was to motivate them to do something. Verbal acts, which are nonverbal statements, like nodding your head, that's the classic example. And finally, statements of prior identification. All right, what's never hearsay? Let's go backwards. Statements of prior identification are never hearsay. Never. You identify someone on the witness stand, that's never hearsay. It's admissible as substantive evidence. Verbal acts, nonverbal behavior, intended as an assertion. Effect on the listener, statements offered for their effect on the listener. You're going to look for evidence of that intent, of that effect. Did it motivate the listener to do something? A statement offered for notice or knowledge, or legally operative language. Okay, 1, 2, 3, 4, 5, legally operative language offered for notice or knowledge. 3, effect on the listener. 4, verbal acts. And 5, statements of prior identification. Okay, hearsay exclusions. Let's look at our prior statements. We've got our prior inconsistent and our prior consistent. What do they have in common? Prior statements have to be made by a testifying witness on the stand who is subject to cross. So our prior inconsistent statement is offered against the opposite side. It's something that they said on the witness stand while they were subject to cross. They don't necessarily have to be crossed on it. So a prior inconsistent statement, what happens if it's under oath? It comes in as substantive evidence. What happens if it's not under oath? You can use it to impeach the witness. So a prior inconsistent statement, why isn't it hearsay? Because it's not offered for its truth. It's just to show the witness is inconsistent and therefore probably not credible. Okay, so here is the two-part test, prior inconsistent statement. 1, to rebut a charge that the declarant recently fabricated it or acted with improper influence or motive. Whereas our prior consistent statement, the testifying witness is on the stand and subject to cross. A prior consistent statement can be used to rehabilitate the witness whose credibility was recently attacked. Okay, prior inconsistent statement to rebut, prior consistent statement to rehabilitate. When do we rehabilitate? Only when their credibility was attacked. Why aren't these hearsay? They're not offered for the truth. They're just offered to show the consistency or inconsistency of the statement. Okay, prior identification, not hearsay, not hearsay. Witnesses on the stand identifies someone that they perceived earlier, not hearsay. Okay, our second category. First category is prior statements by a testifying witness on the stand. We've got 3 of them: prior inconsistent, prior consistent, and prior identification. Second category, opposing party statement. This is offered by the AP, a named party, offered by the AP against the AP, offered by the opposing party, used against the opposing party. That's an opposing party statement, not hearsay. It's excluded. Finally, our third category is an admission made by that party, and they adopted it as their own or believed it to be true. So, of course, there's our regular old admissions. That never happens on the bar exam. But what about an adoptive admission? That's adopted by a person who was authorized to make that statement. Adoption by silence, when that's right, reasonable person would have denied it. What about a vicarious admission? Yes, like vicarious liability made by the party's agent or employee during the scope of employment and while it existed. A vicarious admission is a hearsay exclusion. And finally, our co-conspirator statements made by a party's co-conspirator during, in, and in furtherance of the conspiracy. Does this prove the conspiracy? No. Does it prove the relationship with the co-conspirator? No. It is just considered an admission made by the party's co-conspirator during, in, and in furtherance of the conspiracy. Okay, let's walk through those hearsay exclusions one more time. FRE 801. We've got our 3 categories. What are they? 1, prior statements by a testifying witness on the stand subject to cross. Category 2, opposing party statements. Category 3, admissions. Okay, category 1 is, that's right, prior statements by a testifying witness on the stand subject to cross. Second, opposing party statements. And 3, that's right, admissions. All right, let's break it down. Prior statements by our testifying witness on the stand subject to cross. Prior inconsistent statement. Why is it hearsay, not hearsay? It's not offered for its truth. Used to rebut a charge that the declarant recently fabricated it or acted with an improper influence or motive. Okay, prior consistent statement. By contrast, a prior consistent statement is used to That's right, rehabilitate a witness whose credibility was recently attacked. And 3, prior, that's right, identification. We've got the witness on the stand. They identified someone earlier while they were on the stand and subject to cross. That prior identification is not hearsay. Okay, opposing party statement, very easy. Not hearsay. Anything said by the opposite side, made by a statement made by the AP, we're going to turn around and use that against the AP. Opposing party statement, the AP says it, we use it against them, not hearsay. An admission. Okay, a statement made by that adverse party on one that they adopt or believe to be true. Okay, we've got our regular old admissions, and then we have our, that's right, adoptive admissions, adopted by a party who was authorized to make that statement. Adoption by silence when, that's right, a reasonable person would have denied it. A vicarious admission, like just like, that's right, vicarious liability, made by a party's agent or employee during the scope of employment and while it existed. And finally, we have our, that's right, co-conspirator statement. And what's our legal standard there? Made by the party's co-conspirator during and in furtherance of the conspiracy. Does it prove the existence of conspiracy? No. Does it prove the defendant's relationship with the co-conspirator? No. The co-conspirator statement is simply excluded from hearsay. Okay, moving on. Okay, the declarant's availability is immaterial for the following hearsay exclusions. Okay, they can be there testifying, or they can be out of the picture, or whatever. We have many of these, but they're pretty easy. First one, heavily tested present sense impression. What's our legal standard? Describes or explains the event. 2, made while or immediately after the declarant perceived it. 1, describes or explains the event. 2, made while or immediately after the declarant perceived it. Contrast this with the excited utterance. Relates to the startling event. 2, made while the declarant was still under the stress of the event. Sometimes the difference is in the exclamation points or in the emotion behind that statement. But the 2 words to remember here, present sense impression, describes or explains. Present sense impression, describes or explain. What does present sense impression do? That's right, it describes or explains an event. And when is it made? While or immediately after the declarant perceived it. What could be a present sense impression? Calling 911 to report an accident while you're on the highway. Contrast to an excited utterance. An excited utterance relates to the startling event, made while the declarant is still under the stress of the event. So for present sense impression, describe or explain. Excited utterance relates to the event. And it's made while the declarant's still under the stress of the event. So for an excited utterance, we're looking for a startling event. The declarant makes an utterance while they're still under the stress of the event. Whereas a present sense impression describes or explains the event, made when, while, or immediately after the declarant perceived it. Okay, well, we've beaten those down to a pulp there. Let's go to our then existing mental, emotional, or physical condition, sometimes called the state of mind exception. Okay, state of mind exception is a misnomer. Let's call it what it is. Then existing mental, emotional, or physical condition. Does the declarant have to be there on the stand? No, they do not have to be available. Their availability is immaterial. Okay, Then existing mental, emotional, or physical condition. Forward-looking, remember this is forward-looking, a statement of motive, intent, or plan, as in Hillman, intent to travel, or their emotional, sensory, or physical condition, but not a statement of memory or belief to prove the fact, remember. Then existing mental, emotional, and physical condition is always forward-looking, their motive, their intent, their plan to do something in the future, or their present emotional, feeling, sensory, or physical condition. I have a pain in my foot. I feel sad. But not a statement of memory or belief to prove the fact remembered. So we cannot use the exception if it's backward looking. Someone's remembering something in the past. I believe this happened. According to my memory, this happened. Then existing mental, emotional, or physical condition is always forward looking. And under Hillman, that can include the intent to travel to prove that the defendant actually did travel. What a weird, funky exception here. The exception is unless it relates to the term of the declarant's will. A statement of memory, not a statement of memory or belief to prove the fact remembered, parentheses, unless it's about a will. Okay, number 4, easy. Statements for medical diagnosis or treatment. Made for and pertinent to medical diagnosis or treatment. 2, describes medical history, symptoms, and general cause. Who do we make this to? Any medical personnel, from the EMT all the way up to the surgeon. Statements for medical diagnosis or treatment. 2 prongs. Made for and pertinent to what? Medical diagnosis or treatment. And it describes what? Medical history, symptoms, and general cause. Not Felix did it, but their general cause. Okay, moving on. Business record or absence of. Do not confuse these elements with the public records exception. A business record is made at or near the time of the event by a person with knowledge. It's kept in the course of a regularly conducted business activity. And it's a regular practice of the business to keep those records. Who can show a business record in evidence? Well, of course, the custodian of those records or another qualified witness, or by certification, a certified copy of a business record. But here's our big difference. Public record. Okay, the business record is made at or near the time by someone with knowledge, kept in the course of a regularly conducted business activity, and it's the regular practice to do so. Now let's contrast this to a public record. This is observed while under a legal duty to report. Legal duty, public record, legal duty to report. So, business record, kept in the course of a regularly conducted business activity. It's the regular practice shown by the testimony of the custodian or another qualified witness, whereas a public record sets out the office's activities observed while under what? That's right, a legal duty to report. Okay, public record, legal duty. Business record, regular practice of the business. Okay, let's walk through public record a little bit more. The circumstances of the public record can't indicate a lack of trustworthiness. And of course, in a criminal case, are police record reports ever coming into evidence? No, of course they're not. Okay, remember the absence of a record is shown by the same elements. We can't find a record of this receipt. Well, someone at or near the time with knowledge keeps these records in the course of regularly conducted business activity, and it's their regular practice to keep those records, and the custodian says it's not there. absence of a business record. That is a hearsay exclusion. Okay. Public record, absence of a public record. The record sets out the office's activities, observed under a legal duty to report. It's trustworthy. No police reports. And the absence of can be shown by testimony of the custodian or a certification to show the record didn't exist. I've gone through the records and I certify that there is no record of this person being imprisoned at this point of time. Or we have testimony from a person, the custodian, saying, I can't find any records of this arrest anywhere. Or there are no records of this marriage being performed. That's absence of a public record. Okay, one exception here. Remember, we had an exception for the then existing mental, emotional, or physical condition. Not a statement of memory or belief to prove the fact remembered unless, that's right, it's about the defendant's will. Okay, so public record, absence thereof also has an exception. If it's a criminal case, the prosecutor wants to show it by certification and not testimony, they need to notify the other side within 14 days of trial, and the other side has 7 days to object to this certified public record. Okay, let's go through business records. Made, that's right, at or near the time by someone with knowledge. Whereas a public record is observed while, that's right, under a legal duty to report. Okay, business record, all the elements. Made, at or near the time by someone with knowledge. 2, kept in the course of regularly conducted business activity. And 3, it's the regular practice of the business to keep those records. Who gets to show the record? The testimony of the custodian or another qualified witness. What about a public record? Testimony or certification to show the record didn't exist. And if we're discussing something criminal, the prosecution says, we want to show there's an absence of a public record. Written notice to the other side 14 days before trial, and the other side may object within 7 days. All right, not as frequently tested. Records of religious organizations, records of birth, death, marriage, certificates of baptism and marriage, that the religious official performed the ceremony. Same thing, family records, the family Bible, genealogy, charts, even engravings on a ring or a burial marker or an engraved urn. Okay, learned treatise. Who can offer a learned treatise into evidence? Well, either party, but who does it get read to? It's read into evidence by the expert witness. Read into evidence by an expert witness. Okay, does the other side get it? It can only be offered into evidence by the adverse party, right? And then it's admissible to impeach and for truth. But the learned treatise exception is a reliable treatise read into evidence by an expert witness. The AP wants to use it. Only they can offer it as an exhibit. It's admissible to impeach, and it's admissible for the truth of the matter asserted. Okay, property records. Again, less heavily tested. Deeds, legal descriptions. Now remember, these are legal documents, so they're probably going to fall under self-authenticating documents. They're admissible to prove the contents of the original recorded document, the signing, delivery of a deed. It's kept in the public office. It's recorded according to the recording statutes. Any statement about property boundaries or even customs regarding land use might be admissible, but mostly we're talking property records, deeds, legal descriptions. Don't these fall under self-authenticating documents? Yes, they do. So they fall under 2. Okay, recorded recollection. All right, remember, refreshed recollection has failed. The witness can't recall enough to testify fully and accurately. So you gave them some notes, the refresh failed. Now we can offer a record made by who? The witness. While what? Fresh in the witness's memory, based on personal knowledge or written by another person with personal knowledge. I've seen that too. Accurate when made. Okay, recorded recollection. The witness can't recall to testify fully and accurately. The record was made by the witness while fresh in the witness's memory, made by the witness based on personal knowledge or written down by another person with personal knowledge, accurate when made. Okay, do these get read into evidence? Yes, yes. Refresh, no, we take that document away. Recorded, it's read into evidence, and therefore it is admissible to impeach and for its truth. Can this be received as an exhibit? Well, not unless it's offered by the adverse party. So the adverse party gets to inspect the document, they get to cross with it, they get to show it to the jury. But our basic recorded recollection, read into evidence by the witness. All right, the witness, number 1, can't recall. The record was made by who? The witness, while, that's right, fresh in the witness's memory, made by the basis of, that's right, personal knowledge or by another person with personal knowledge, accurate when made. And can we receive that as an exhibit? It's read into evidence. So the AP can offer it into evidence. They can inspect it, cross with it, and show it to the jury. Okay, ancient documents made before 1998, whose authenticity cannot reasonably be questioned, found in a place where they would likely be if they were authentic. That's an easy one. Okay, so next up, when the declarant is unavailable. So all of these exclusions and exceptions, it doesn't matter whether the declarant is there or not, but we only get 3 when the declarant is definitely not available. What makes a declarant unavailable? It's not just because they're sick or dead. They claim a privilege. They refuse to testify. They can't remember, or they're outside the subpoena power of the court. All of those things make a declarant unavailable. 1, that's right, privileges. 2, refuses to testify. 3, can't remember. 4, outside the subpoena power of the court. And finally, they could be dead. They could be made, we could have a forfeiture by wrongdoing scenario here. All right, but remember, we only get 3. The dying declaration, rarely tested, statement made under a belief of imminent death about the circumstances or cause of death. Does the person have to actually die? No. They just have to make a statement believing they're about to die about the circumstances or cause of their death. Who did it? Number 2, statement against interest. So against that person's penal or financial interest that a reasonable person would have denied it. Statement against interest, so against their penal or financial interest that a reasonable person would have denied it. Okay, if the statement against interest is in a criminal case, what do criminals do if they're making a statement that's against their interest? Let's say we're trying a drug case. Drug dealer is probably going to lie to protect his boss, isn't he? So a criminal statement against interest must be supported by what? Corroborating circumstances. Okay, continuing. Former testimony under oath. Former testimony under oath. Why is this different than prior inconsistent statement? Oh yeah, it's because the declarant is unavailable. Remember, we only get 3: dying declaration, statement against interest, 3: former testimony under oath. Former testimony under oath. Witness is unavailable. They previously gave sworn testimony at the current hearing or a different hearing, or perhaps at a deposition. Can we use their affidavit? No. It has to be oral testimony. Same subject matter, and the defendant had a similar motive and opportunity to question or cross at the previous hearing. Okay, let's walk through that again. Former testimony under oath. How is this different than prior inconsistent statement? The declarant is unavailable. That declarant gave sworn oral testimony at a current hearing or a previous hearing about the same subject matter, and the defendant had a similar motive and opportunity to cross at that hearing. Okay, what does this look like? We have a deposition, and we're talking about the same subject matter. Both sides have an opportunity to question or cross at the deposition, right? Therefore, it's former testimony under oath. Can we use affidavits? No. Okay, so we only get 3, right? What are our 3 declarant unavailable exceptions? Dying declaration, that's right. Statement against interest, so against their penal or financial interest that a reasonable person would have denied it. What do we need if it's a criminal case? Oh yeah, corroborating circumstances, because a criminal might lie to protect the higher up. And 3, former testimony under oath. They gave sworn testimony previously, same subject matter, similar motive and opportunity to cross. Okay, let's talk real quick about forfeiture by wrongdoing. If the declarant's conduct caused the witness to be unavailable, they lose all their confrontation clause and all their hearsay exceptions. You caused the witness to be unavailable yourself. No longer do you get any confrontation clause rights. They're gone. Okay. One more bit of hearsay, and that is the confrontation clause itself. Now we know we can forfeit, the declarant can forfeit those confrontation clause rights, the right to confront witnesses against you, if they cause the declarant to be unavailable. Okay, and remember, they don't have to kill them. They could just have them claim a privilege, refuse to testify, say, I can't remember. Or they can run outside the subpoena power of the court. All of that would count for forfeiture by wrongdoing. You can forfeit those confrontation clause rights. But what are the 2 main prongs? What's inadmissible? That's right, testimonial evidence used to aid in prosecution or criminal investigation. Testimonial evidence. Any testimony used to aid the prosecution or investigation. And that includes test results, blood tests, hair samples, all of that. But what's admissible? Non-testimonial evidence used to assist the police in an ongoing emergency. All right, don't switch these. It's easy to do it. Non-testimonial evidence. What's our legal standard? There's an emergency going on. Is that evidence admissible? Yes. We're trying to assist the police in an ongoing emergency. That's considered non-testimonial evidence, and it is admissible. Okay, so if you're assisting police in an ongoing emergency, are you a witness against the defendant? No, you're just trying to help out. Okay, what about testimonial evidence? Would you need to confront that witness against you if you were the defendant? Yes. Why? because you're using that evidence to aid the prosecution or investigation. Is that admissible? No. Inadmissible, testimonial, used to aid the police. Inadmissible, non-testimonial, used to aid the police in an ongoing emergency. Actually, I misspoke. Inadmissible, testimonial evidence used to aid in the prosecution or investigation. Non-testimonial evidence is admissible because it's just used to help the police in an emergency. And that's the end of hearsay.